There's a genuinely significant legal case unfolding right now that I think matters considerably more to Harry's actual future than the Daily Mail loss most people are already familiar with. And almost nobody in mainstream coverage seems to be treating it with the seriousness it actually deserves.
Fortunate position that he's not the claimant, he's the defendant. The judgment, always public. Would he be humiliated? Enormously. The embarrassment of the discovery process is nuclear, it really is.
It doesn't involve Harry suing anyone. This time, he's the one being sued by Sentebale, the charity he founded in his mother's memory, meaning Forget Me Not, built to support children living with HIV in Lesotho and Botswana. Let's actually walk carefully through what's genuinely happening here, step by step, because underneath what initially sounds like fairly ordinary charity board drama sits a genuinely significant legal mechanism that could meaningfully shape the next 2 full years of Harry's entire public life going forward.
Harry quit his role as patron of Sentebale. He and the co-founder, Prince Seeiso, stated that they resigned with heavy hearts, were in shock, and felt the relationship with board chair Dr. Sophie Chandaka had broken down beyond repair.
Start with the basic timeline. In March 2025, Harry and Prince Seeiso of Lesotho stepped down from Sentebale, describing a relationship with the board chair that had broken down beyond repair. That's the polite, official version. What followed was a wave of anonymous, unflattering briefings to American outlets about the chair, Dr. Sophie Chandaka, the kind of unattributed coverage that's become a familiar pattern around this family over the years. Here's where I want to be genuinely careful, because this is exactly the point where a story like this can go badly wrong if handled sloppily. Sentebale's legal filing reportedly claims Harry and his associate Mark Dyer coordinated that adverse media campaign. That's a claim, pleaded in a legal filing, not yet proven in any court. Harry and Dyer have categorically rejected it. Nothing here confirms the campaign happened as alleged.
Then little leaks to American news outlets started to pop up that were even more scathing towards Chandaka, shielded by the veil of anonymous sources.
What this video is actually about is the legal position Harry now occupies because of that claim, which is genuinely difficult regardless of whether the underlying allegation turns out to be true. Chandaka had already taken this to the Charity Commission before escalating to the High Court. And it's worth being precise about what that regulator actually found, because both sides have reportedly spun it in their favor. The commission found no evidence of widespread or systemic bullying at the charity, and found no overreach by either the chair or the patron specifically. On those core points, it's a genuinely clean finding for Harry's side. What it did note was that the broader public dispute had damaged the charity's reputation, regardless of who was more at fault.
And we don't actually know what the charity claims they've done. We simply know Sophie Chandaka claims that they've organized a tremendous media campaign against her and against the charity.
Here's the detail that matters most, though. A regulator's report isn't a court judgment. A regulator can't compel disclosure of private communications. A high court judge can. That distinction is about to become genuinely significant. If this kind of detailed legal breakdown is useful to you, the like button genuinely helps this channel keep digging into stories that deserve more careful treatment than a quick headline. It's worth pausing here to note something genuinely important about how legal proceedings like this typically unfold in the public conversation. Before we go further, charity governance disputes are actually fairly common across the nonprofit sector generally, and most never escalate to formal litigation of any kind. Boards and executives disagree, relationships sour, people step back, and things usually resolve quietly without ever reaching a courtroom. The fact that this specific dispute escalated all the way to a high court libel action is itself somewhat unusual, and worth flagging as a meaningful indicator of how seriously at least one side is taking the underlying disagreement.
She's blown the whistle once before on Harry. She took the, how shall I put it, unorthodox but very clever step of reporting the charity to the Charity Commission, which is the British regulator of charities. Is actually fairly toothless, but that's another discussion.
Now let's get into the actual legal mechanism that makes this particular case so genuinely different from every previous legal fight Harry has been personally involved in, because I think it's honestly the single most important thing to properly understand here. English defamation law works differently from American law in a way that matters enormously for this specific case. In the United States, a person suing for defamation generally has to prove the statement was false. That's a genuinely high bar, rooted in First Amendment protections, and it's part of why American defamation suits are comparatively rare and difficult to win. English law reportedly runs in the opposite direction. A defamatory statement is presumed false from the outset, and it falls to the person who made it to prove, on the balance of probabilities, that it was actually true.
Actually did a sort of mealy-mouthed report in 2025, and it sort of said everything is for the best in the best of all possible worlds, and it wasn't finding her a liar, and it wasn't finding Harry a liar, and the sun was shining, and all they basically said was that it's unfortunate that they both brought in publicity that was no good for the charity.
Sit with what that means for Harry's position specifically. In every previous legal fight, the Mirror, the Sun, the Mail, the Home Office, Harry was the claimant, choosing his own timing, controlling the pace, able to walk away if the arithmetic turned against him. In this case, he's the defendant. He didn't choose this fight, can't simply withdraw from it, and under English defamation law, the burden of proof reportedly sits with him rather than with Sentebale. There's a potential defense available: honest opinion on a matter of genuinely public interest, which charity governance involving a prince plausibly qualifies as. But according to legal commentary on the case, that defense is reportedly narrow in practice. It protects genuine opinion, not fabricated claims. Establishing which category any specific statement falls into requires the disclosure process. And that's where this case becomes genuinely serious.
This lady, you know, is very well qualified. She's a lawyer. She has had very important positions with banks and with financial institutions before she came to join the charity. And she's a very tough cookie and very clever.
In English civil litigation, disclosure functions similarly to American discovery. Both sides are required to produce relevant documents, communications, and records. One barrister commenting on this case reportedly described it bluntly as something close to a legal nuclear weapon in this context. Emails, messages, communications with journalists, potentially going back years, with essentially nothing shielded except direct attorney-client communication. That's a genuinely striking and somewhat ironic position for Harry to find himself in specifically, given just how much of his broader public identity over the past several years has been built around positioning himself as the target of unwanted, invasive media scrutiny, rather than as someone whose own private communications might end up compelled into public view through an entirely different legal channel. This particular legal process would potentially require him to hand over exactly the kind of private communications he spent years arguing should remain protected from exactly this kind of exposure, though this time compelled by a court process he's on the defending side of rather than one he initiated.
She claims that the Duke's team asked her to defend his wife Meghan from negative publicity. And she says that she said, no, we're not setting a precedent by which we become an extension of the Sussex PR machine. So that's pretty hot, isn't it?
According to reporting on the case, disclosure could reportedly extend to private messages between Harry and Meghan specifically discussing Sentebale, potentially covering the full period of their involvement with the charity rather than just the period after the dispute became public. Whatever those specific messages actually contain in reality, having years of genuinely private correspondence between the two of them potentially entering a public court record is a genuinely significant exposure on its own, regardless of what conclusions anyone eventually draws from the actual content once it surfaces. One barrister commenting on the case reportedly noted, when the question of deleting communications came up, that doing so would be illegal. A point raised as a hypothetical observation about the law generally, not an accusation that anyone has actually done or plans to do this. I want to be clear that including this detail isn't suggesting evidence tampering has occurred. It's included because the barrister's comment itself became part of the public discussion around the case's legal stakes.
She says that the number one risk for this organization, meaning Sentebale, was the toxicity of its lead patron's brand. So obviously all that's going to come out at trial. This is going to be gripping stuff.
Now, on timing specifically, because this is where Harry's position differs most sharply from his previous legal experience. In every prior case, he controlled the calendar: when to file, when to settle, when to walk away. In this case, Sentebale reportedly controls the pace as the claimant, deciding when to push forward and whether to eventually settle or proceed to trial. reports suggest a trial isn't expected before late 2027, meaning this specific legal exposure could extend across roughly 2 full years, landing in the same year as the Birmingham Invictus Games, an event Harry has invested enormous personal and reputational capital into.
Bauer's betrayal, he does have a source close to Sentebale that says that Harry's brand and that Harry's just toxic activity over the last 6 years negatively affected their ability to fundraise in general.
It's worth being genuinely fair to Harry's specific legal position here too, before moving to the financial dimension of this case. Facing a reversed burden of proof doesn't automatically mean losing. It simply means the legal starting point is less favorable than what he's grown accustomed to across his previous litigation history. Plenty of defendants in English defamation cases successfully establish truth or honest opinion despite carrying that burden. And there's no indication yet that Harry's specific legal team considers this an unwinnable position. The burden shift changes the difficulty, not necessarily the ultimate outcome. Let's talk about cost now, because defamation litigation in England is reportedly among the single most expensive categories of civil litigation that exist anywhere in the legal system.
Fortunate position that he's not the claimant, he's the defendant, so he's got no choice but to defend it. You know, he chose to bring all his other battles. Some went well for him.
One example cited in legal commentary on this specific case involved a claimant winning £140,000 in damages while facing roughly £10 million in associated costs, illustrating how disproportionate the financial exposure can become regardless of the actual outcome. Which raises a genuinely fair question. How does a relatively small charity supporting children in Lesotho and Botswana fund a multi-year high court libel action at that potential cost scale?
You can show it's true. And the burden of proof, as I've told you previously, in England, unlike in America, in England, the burden is on the defendants. It's on Harry. So it's assumed to be untrue when she sues him. Assumed to be untrue unless he can prove it's true. And he has to prove it on what's called the balance of probabilities. He has to show that it's more likely than not that she is whatever he called her.
Sentebale's stated public position is that legal costs are being met through external funding rather than charitable donations, which is a reasonable, responsible thing for a charity to clarify. What remains genuinely unclear is who that external funding actually comes from. There's speculation circulating about whether a media organization with its own history of legal conflict with Harry might be involved in underwriting this specific litigation. I want to be extremely clear that this is explicitly labeled as speculation even by the people raising it, described directly as a guess rather than anything confirmed. I'm including it here because it's part of the public conversation around this case, not because there's solid evidence behind it. If accurate, it would represent a genuinely notable strategic shift. Media organizations that Harry has previously sued successfully potentially funding opposition through an entirely different legal avenue. But that remains speculative, and treating it as established fact would be irresponsible. Now, there's a broader thematic thread running through this entire case that I think deserves real attention, because it connects to something that's apparently been a recurring pattern for this family specifically. According to reporting, Chandauka has characterized part of the underlying dispute as being asked to help manage press coverage connected to Meghan specifically, describing herself, in her framing, as being expected to function as something like an extension of Sussex-focused publicity efforts. Harry's side has reportedly rejected that characterization of events. Whatever actually happened, the framing itself, a charity's leadership feeling pulled toward managing a patron's personal brand rather than the charity's actual mission, echoes a dynamic that's reportedly surfaced before in this family's history. There's a specific story that's circulated for years involving Meghan and royal household staff during an earlier public engagement, where the visible controversy around a moment ended up overshadowing the actual charitable purpose of the visit, with a phrase reportedly used by royal staff at the time along the lines of, "The focus is the charity, it's never about you." Whether that specific historical account is accurate in every detail, the underlying tension it describes, patron visibility potentially overshadowing charitable mission, is precisely the tension Sentebale's case is now formally alleging in a legal filing, which is a genuinely interesting thread connecting an older informal anecdote to a current formal legal claim. I want to draw a comparison here that I think is fair and worth making, without suggesting anything definitive about either brother's character. William has, by every available public account, never faced a comparable legal situation connected to any charity he's associated with. No libel action, no regulator complaint escalating to court, no public dispute of this scale and duration. That's worth noting as a genuine contrast, though it's also fair to note that different circumstances, different organizational structures, and simple chance all play a role in why one brother has faced this specific kind of legal exposure and the other hasn't. It's not necessarily proof of a fundamental character difference. It may simply reflect different choices, different organizational contexts, and different luck. There's also a separate claim reportedly connected to this broader dispute involving security concerns for William and Catherine specifically, tied to unaddressed online harassment following public statements. I want to handle this carefully because it's a serious claim that deserves precision rather than amplification without context. The underlying legal theory being reportedly argued isn't that Harry directly incited any harassment, but something closer to a claim that public statements left ambiguous enough space that harassment followed without ever being explicitly discouraged. A legal theory sometimes compared, in commentary on the case, to the historical account of Henry II's remarks about Thomas Becket, where an ambiguous public complaint was followed by unauthorized violent action, without any direct order ever being given. Legal commentators discussing this specific theory have reportedly noted it would be genuinely difficult to prove in court, which is worth including as a meaningful check on how strong this particular argument actually is. It's also worth naming honestly that the funding speculation, however carefully labeled, illustrates a genuine limitation of commentary like this specific kind. Without concrete, verifiable evidence about the actual funding source, any theory here remains exactly that, a theory, regardless of how plausible it might sound given the broader context of Harry's litigation history with the British press. I think it's fair to flag the question as genuinely interesting and worth continued attention as this case develops, while being honest that nobody currently has a confirmed answer and pretending otherwise would be irresponsible regardless of how compelling any particular guess happens to sound. Let's step back now and consider the broader financial and reputational context this specific legal case is landing inside, because it's genuinely not unfolding in isolation from everything else currently happening around this family. The commercial ventures that were meant to provide Harry and Meghan's primary post-royal income have reportedly struggled recently. The Netflix lifestyle brand relationship reportedly ended, the cooking show concluded after 2 seasons, and a broader production arrangement was reportedly downgraded to a more limited agreement. None of those specific commercial setbacks are directly caused by the Sentebale litigation, but they do mean this expensive multi-year legal exposure is arriving during a period when the financial cushion available to absorb it may be considerably thinner than it once was. So where does all of this actually leave things at this current stage? And I genuinely want to be careful and thorough with my closing caveats here before we wrap up entirely. Nothing whatsoever in Sentebale's specific legal claim has actually been proven in any court of law at this point in time. It remains, at this stage, purely a legal pleading, and both Harry and Mark Dyer are fully entitled to their complete rejection of it unless and until an actual judge formally determines otherwise through the legal process. The Charity Commission's specific finding of no systemic wrongdoing whatsoever on the core underlying allegations is genuinely real and genuinely favorable to Harry's overall legal and reputational position here. The specific detailed pleadings in this particular case aren't fully public yet at this stage, meaning the exact scope and wording of the underlying allegations remain somewhat unclear from outside reporting available to the public, and legal commentators discussing this specific case have reportedly acknowledged openly that proving the central claim, that Harry specifically orchestrated a coordinated campaign against her, may prove genuinely difficult for Chandauka's side to establish conclusively in court. Winning this specific case outright, if Harry ultimately does manage to, genuinely isn't necessarily the same thing as escaping the entire process unscathed or without meaningful reputational and financial cost along the way. Even a fully successful defense would still, by every indication, likely require going through the entire disclosure process regardless, still require actively defending either truth or honest opinion under that reversed burden of proof, and still mean roughly 2 full years of ongoing litigation exposure landing at an already genuinely difficult moment for his broader public standing and commercial position overall. What do you genuinely think? Does this reversed burden of proof under English defamation law meaningfully change how you personally read Harry's overall position in this specific case? Or is this ultimately still going to resolve in his favor regardless, given how clean the Charity Commission's earlier findings genuinely were on the core allegations? And separately, do you genuinely think the funding question, specifically who's actually underwriting this multi-year litigation on Sentebale's behalf, deserves considerably more sustained scrutiny than it's currently receiving in mainstream coverage, or is that genuinely just unfounded speculation that isn't worth taking seriously without real, verifiable evidence behind it? Let me know your genuinely honest take on all of this down in the comments below. I read every single one, and they genuinely help shape which stories we dig into next. And if you appreciate more careful, properly caveated legal breakdowns like this one, rather than just repeated, oversimplified headlines, go ahead and subscribe to Palace Insider right now so you catch the next update on this case the moment it develops further. And if tonight's video gave you something genuinely worth thinking about, drop a like on your way out. It genuinely helps this channel keep growing and reaching more people who want the fuller picture.